The trial of Lindsay Clancy in Massachusetts, a mother accused of killing her children. The defense began their portion of the trial this week. Again, 3 weeks of prosecution. The defense now taking over her case here. Now, the team here does not dispute that she killed her children, but said that she shouldn't be held criminally liable because she was suffering from postpartum depression, psychosis, mental illness that's been linked to stress and hormone changes after childbirth. So it's essentially not guilty by reason of insanity, but in Massachusetts state law, lack of criminal responsibility. We wanted to talk more about this, so let's bring back defense attorney Marsh Halberg that we talked to you a couple days ago about a different legal case, but this is one that is very interesting. I know a lot of people have been keeping track of this. This is one, first of all, why do you think that cases like this attract so much interest and attention? A mother here who, again, doesn't dispute that she caused the deaths of her children, but is really focused on the why of it. Mental health becomes such a very interesting topic in these cases.
Right, it really strikes a chord, right? This gal looks like a pretty, middle-class person, a nurse, kind of a normal life. And I think a lot of people can relate to that. A lot of people, either their own families or they know of people with postpartum issues that have come up after birth. So it kind of strikes a chord that many people can relate to. And you contrast that with kind of this really nice person who seems to have been fairly well balanced up until recently, till just a couple of years ago when the death happened. And you compare that to just the grisly fact of strangling 3 of your small children.
Now, again, this is, how is Massachusetts law, I guess, different from Minnesota law? Again, it's lack of criminal responsibility, arguing she's not guilty because she lacks that responsibility. It may be called an insanity defense. It's not called that there. How does that work in Massachusetts law? What's the difference between if we saw a case like this here?
Big difference. I think it'd be tougher to win this case in Minnesota than it would there. There's kind of two main camps of how you deal with definitions for mental illness in criminal cases. One is called McNaughton. It's a McNaughton standard. It's way back from the 1830s. It kind of came into favor, Rob, back then and kind of worked its way through the system. There's kind of an erosion that fell away from that, and courts started to do other instructions. And then 1981, John Hinckley Jr. attempts to assassinate Ronald Reagan. He's found not guilty by reason of mental illness because of the instructions. There's kind of a big uproar. There's federal legislation at that point to tighten up the definition and go back to this McNaughton standard, and a lot of states followed suit. Minnesota was already there. We already had the McNaughton standard, which is basically kind of shorthand known as the right-wrong test, that you know right from wrong. That's kind of the basic definition that we have here. Massachusetts went a different way. There's a thing called the model penal code, that has a different definition. And it's a subtle difference, but instead of having to know right from wrong, it's just appreciating what's right from wrong, which is kind of a lesser step for what they have. And the big difference is in Massachusetts, they have kind of a two-pronged way you can escape liability. One is this don't appreciate right or wrong. The other is that it's almost an irresistible impulse that the way they use the word, you can't comply with what that is. So even though you know you shouldn't be doing this, you just can't stop yourself, kind of a mentality. So that's what they have there, which gives another bite of the apple for the defense as far as why they should win.
What's interesting here, Marsh, is again, 3 weeks of the prosecution side, more than 70 witnesses, including doctors and psychiatrists, et cetera, including a lot of testimony about her mental health and about medications she was or was not taking. So it seemed like the prosecution really presented a lot of evidence about her mental health struggles. Why would they do that if that is also a key part of her defense strategy?
Really good point. This is where lawyers start to strategize. Very common in my experiences of doing these cases in Minnesota that you enter stipulations with the government. If we are only fighting over the mental illness defense versus the whether you did it or not, you can have a stipulation that you write out with the government that even may be read to the jury where the parties have agreed that the death was caused by the defendant or the judge if you have a judge trial. But in this case, interesting, the defense wanted to do that. Said, we'll agree that she caused the deaths. Let's just fight over mental illness. And the state refused to do that. They said, no, we have the right to put in our case. We don't have to stipulate. You can't make us do that. So therefore, we want to kind of taint or affect the jury by having them sit through 70 witnesses to hear about the very grisly facts and the detail of how it all unfolded to really try to impress upon them what a horrible set of crimes this was.
But again, when you look at what's the prosecution doing then if they're calling up all these witnesses that do get into her mental health struggles? Is that the prosecution trying to say for the jury, yes, these were there, but somehow didn't cross a line into lacking responsibility? What is the prosecution's intent with that?
The strategy there is they're trying to get ahead of it. They know what the defense is going to be, right? And they know what some of those facts are. They know what the medical records say, exactly what some of them talk about. And they know that these family members in support of this woman are going to come forward and say she was spiraling out of control. She was begging for help. She was desperate. She wasn't sleeping. She was on 12 different medications in the course of a year for depression and those types of things, tried to be hospitalized, all these kinds of things that are out there. So they need to get ahead of those to try to spin it back the other way. For example, we know that the defendant jumped out the second floor window right after this happened and attempted suicide. And so the spin for the state will be, well, she was doing that because she knew she had just killed three of her children. The defense is going to be, no, this just shows how out of control she was, being so distraught and everything else. So they're just trying to get ahead and put their own spin on the evidence they know is going to come in anyway.
So what is the burden then to prove this level of mental illness for this defense? I mean, is that how high a bar is that, in court in Massachusetts?
Really good question, Rob. So the difference is, Massachusetts has what they call a unitary or one-step trial. If you want to say, I didn't do it, or I didn't do it because I'm mentally ill, either or both of those, you have one trial, the jury kind of hears everything at one time. In Minnesota, if we say, I'm pleading not guilty that I didn't do it, and if you believe I did, then we're going to have a second step of the trial. So in Minnesota, we actually have a first half of the trial where we just have evidence over whether you did it or not. Then the jury, if they find the person guilty beyond a reasonable doubt, then you come back and say, okay, now we have a second step for you jurors to decide is she not guilty by reason of mental illness? That is the burden in Minnesota on the defense attorney by what's called the preponderance of the evidence, which is 50-50, right? You put evidence on a scale and whoever has 51% wins. So the burden in Minnesota is on the defense to prove what we call Rule 20 evidence in Minnesota. By contrast, and it's a big difference, in Massachusetts, what they do is once the defense gives notice of mental illness, the burden then falls on the government to prove beyond a reasonable doubt that she wasn't so mentally ill to have her found not guilty. So big difference.
Okay. Is there a reason there would be, or a benefit to a jury trial versus just a judge trial in a case like this with a mental illness defense?
Right. So there are a couple of things that usually I always tell my clients, I get to drive the car. I get to decide what witnesses we call, what order we call them, what we're going to argue, how we're going to argue it. But there are a couple of things that the defendant always decides. And that is one of the main ones is you have a judge or jury trial. That's up to the defendant to decide of what they want to do. Here, a lot of times, if you want to win a case on more of a, I don't call it technical issue, but not really on the facts, but more of a subtle issue, sometimes you consider it being a judge, because it'll be a judge who says, I'm going to hold my nose. Clearly this horrible crime has happened, but I'm going to find him not guilty because I got to follow the law. And the concern is that a jury may not do that. Here, though, and again, because it's such a grisly kind of a situation, you kind of would shy away initially from wanting a jury because, man, they are not going to like this woman for all the evil things she did. But on the flip side, she presents really well. She's just sitting there in court, but everybody around her mother, her mother-in-law, her other family members, her ex-husband, co-workers. They're all getting up. They're just nice middle-class folk getting up and saying, this lady is a wonderful person and she just lost it towards the end. So you hope that that's there.
Now, let's talk about the potential outcomes here, guilty versus not guilty. She's been held on a court-ordered mental health treatment since May of 2023 in a hospital in Massachusetts. She's still there. If she's found guilty versus being found not guilty, you would assume that she's still going to be in mental health treatment. Is there going to be, what is the difference, I guess, for her in the outcomes of this trial?
Right, and that's part of what the jury does or doesn't know. Generally, the jury is being told, you don't concern yourself with the ramifications or consequences of whatever decision you make. So some of them are, I'm sure, saying, my gosh, I don't want to let this person be found not guilty if they're going to just get to go skip down the street and, happy ever after. But some of them will know, or they will figure that out, that you just don't go free. You remain in a state facility, a lockup facility, until such point as you are deemed to be rehabilitated. And that's what we do in Minnesota with St. Peter, right? If somebody's found not guilty, they send them, generally, one of the options, you can go to St. Peter, and you stay there, and some people never, ever get out. And that can be for a number of reasons. But there are some people who, through medication and passage of time and treatment, actually can come back to have a more stable life and could be eligible for release. And this would be the kind of case of, that you could say this was situational. This lady was only impaired because of postpartum. She's not having more children. She's not going to be subject to this again. She's had years of treatment waiting for this trial. At 3 years we've been sitting here. 3 years she's been in treatment waiting for this. So this could be a case where she could get out on a shorter length of time than obviously a life sentence on murder.
Okay, so the difference here would be, she may continue to be held in a facility regardless of the verdict, but if found guilty, if she's released, then she would be then remanded to custody to serve a sentence versus getting out. But in the meantime, she may still be held in a facility.
Well, no, she doesn't serve a sentence. If she's found not guilty by reason of mental illness,
she would still be held. If she's found guilty, though, presumably she may still be in a facility for some time to come. But then if she does become eligible for release from a mental health facility, would then be remanded to custody.
Right. Well, she has the physical problems, right? Because she's paralyzed from the waist down. So she has medical issues as well to deal with. So it's whatever they have as far as a safe incarcerated type situation to attend to medical care. And we're getting to have more and more of that as the population across the country, the prison population ages. We're having more and more where there's medical issues for these prisoners versus just locking them up till their time is done. Okay.
One last question here, and I don't know if what your thoughts are on this. But how important are these cases for the criminal justice system, for lawyers, for the community at large to really take a really good look at mental health as it pertains to actions like this?
I think it's been a great deal. This is, as you've mentioned, this has a huge following across the country because it relates to a lot of people. And the problem we have is there's just not enough beds, not just Minnesota, anywhere in the country. I think there's a real shortage for mental health counseling and intense help. And I think that really sparks that. We've all known people that have struggled with mental health, right? So I think there's a real value to this, and I'm glad it's being publicized.
Okay. Marsh Halberg from Halberg Defense, thanks again for joining us. Appreciate your legal insight into some of these, again, fascinating cases, extraordinarily complicated, a divergence of opinions depending on your perspective on situations like this, and always the questions of what's the right thing to do for people in these situations.
That's right, Rob. Yeah. It's interesting to watch the outcome of this one.
Yeah. All right, Marsh, appreciate the time.
Thanks, Bob.